Hello, my name is Gordon McNeely. I'm the chair of the Standing Committee on Health and Social Development, this is our Wednesday meeting for July 21st, 2021. First thing, can I get a motion to adopt the agenda? Remember, Carla Bernard. Joining us are members Zach Bell, Carla Bernard, Rob Henderson, and Trish Altez is here with us today. And as well, we have a visiting member, Ola Hammerlin. Thank you for coming. So this is an important topic, and what we'll do is we're really excited to have Mary MacDonald here and her son Reese coming to assist, and Charlotte MacAulay too as well. So without further ado, what I'll do is I'll pass it over to you, and we'll get your brief presentation. Then we'll save our questions for the end, if that's okay, and then we'll go from there. So I'll pass it over to our guests.
Thank you very kindly for your time and generosity in agreeing to meet with us here today on this very important topic. We're speaking from our own lived experience. Myself having been an adult adoptee, born and raised here in Charlottetown and in Eastern PEI. I spent my childhood on the island, and I was adopted as an infant. My birth mother, her name was Verna Isabella MacLeod. She was a 20-year-old woman who gave birth to me just a stone's throw from here at the Charlottetown Hospital. When I was an infant, a newborn actually, when I was 10 days old, Mr. Walter Baker, who was the executive director of the Protestant Family Service Bureau and a social worker, took me from the Charlottetown Hospital to a foster home in Mount Herbert. I remained there until I was 14 months old. At that time, Walter Baker gave temporary guardianship of me to my prospective adoptive parents. My mother, Verna Isabella MacLeod, signed a surrender order a month after I was born in the presence of Walter Baker of the Protestant Family Service Bureau. That surrender document was not legally binding because it was not executed properly. A month after my birth, my mother, Verna Isabella MacLeod, left the island permanently to go live with her older sister in Toronto. When I was an infant, Walter Baker applied for family allowances, which were paid to the adoption agency through family allowances federal office here in Charlottetown. I was transferred to the home of my adoptive parents when I was 14 months old. When I was a year old, Walter Baker discovered that the surrender document had not been properly executed. It took them a year to figure this out, although on the board of directors of this organization were several prominent individuals, among them Queen's Counsel lawyers. They had to track down my birth mother in Toronto and have her go personally to the Children's Aid Society in downtown Toronto to execute a second surrender order. I have a document here that I gave to the clerk of the Legislative Council. I'd like to hold it up for you for your examination. This is a letter written by Walter Baker to Alfred Tate, the Director of Family Allowances here on the island, a federal government agency. Now, I observed very carefully the discussions that took place in the legislature among elected lawmakers debating the merits of the Adoption Act. It did seem somewhat surreal to me because those present seemed to tiptoe around these issues and never really directly dealt with the substantive issues. In particular, I was struck by the two expert witnesses who were called on behalf of the government of Prince Edward Island, who attested to the purported secrecy that was supposedly lifelong anonymity to birth mothers who surrendered their children for adoption on the island. I knew that instantly to be patently false and to be, there's no merit whatsoever. My birth mother's name was never a secret. I have this document. Could you please hold it up, Reese? Again, it's a letter written by Walter Baker, and I want you to remember this name because this individual single-handedly and collectively with other scoundrels at the Protestant Family Service Bureau handed me over as an infant, a trusting and innocent infant, to my torturers and my tormentors without a shred of taking a moment to investigate their qualifications or their suitability to parent an innocent child. So the two expert witnesses who appeared before elected lawmakers here on the island, attesting to this, and this is critical because this is the assertion on which the entire edifice of this law encoded in the Adoption Act is predicated. It's this enduring institutional myth that birth mothers were granted lifelong anonymity. In none of the papers and the documents submitted to the legal authorities here on the island, please hold up the adoption papers. Okay, here, for example, and with the sworn affidavit that contained perjured information that was sworn under oath by my adoptive parents. My birth mother's name is clearly visible. Her name was never kept a secret. And furthermore, I'd like to briefly discuss with you how illegitimate children came to be classified as such. Could you hold up that table, the chart, please, Reese? So, children who were illegitimate were categorized separately, and they were the ones likely to come under the gaze of these child welfare bureaus on the island. So the PEI government defined illegitimacy as a child born to an unmarried mother, a separated mother, or a widowed mother. Those were the three categories of women who, let's be frank about this, they were treated as fallen women. And another myth that needs to be dispelled is that these child welfare agencies involved and to whom were delegated responsibilities to adopt the children of these women. They were not acting with malevolence. We need to dispel that myth. They acted with malice against these women who they deemed to be fallen women. Again, those who were involved and enthusiastic supporters of, in my case, the Protestant Family Service Bureau, don't for one moment think that these were folks who didn't know any better. They were committing and perpetrating human rights abuses. And these human rights abuses were aided and abetted by members of the judiciary who did not take the time to detect perjured information that was contained in sworn affidavits. The legal profession was implicated in these human rights abuses, and the social work profession was also implicated with their involvement in the coercion, the shaming, and the humiliation of unmarried women who were demonized, who were treated brutally when their newborn babies were taken from them and given as commodities without so much as a moment of taking the time to investigate the suitability or the background. In my case, I was handed over as a human sacrifice, as a trusting, innocent baby, to a well-known alcoholic, a notorious alcoholic, and I have presented you with documented medical evidence from numerous doctors who have attested to my adoptive father's chronic, long-term alcoholism. We're not just talking about someone having, a drink or two now and then. This is drinking throughout every single day of my childhood. I had to witness the most vitriolic marital discord, fighting, intoxication, drunk driving, abuse, verbal abuse, threats, humiliation, belittling, threats from my adoptive mother that she was going to send me to the girls' reform school in Truro, Nova Scotia. I heard these threats regularly. No one came to my aid. No one took the time to come to the adoptive home in Georgetown or Wood Islands to check on my welfare or my well-being. What I went through as an innocent child was virtually unsurvivable. This was sanctioned by the government of Prince Edward Island, by the judiciary of Prince Edward Island. And now they're trying to revive this myth that birth mothers were granted lifelong anonymity. There is not a shred of evidence to prove that. And there's an abundance of tangible evidence to disprove that. And this intergenerational abuse has reached now the third generation of my family. My birth mother was demonized and brutally treated. When her newborn infant was taken from her by people who had it in for single mothers. This is no longer a matter of dispute. The United Church of Canada has formally apologized for its role in these heinous crimes. Other countries, including Australia, Northern Ireland, the Republic of Ireland, and now Scotland, have conducted comprehensive investigations and issued apologies, heartfelt apologies to the mothers who were treated with such utter contempt and disrespect. And I would respectfully request of you as lawmakers to lobby your fellow elected officials on a bipartisan basis to issue a posthumous apology to my mother, Verna Isabella MacLeod, and other birth mothers who have died before these issues have been resolved and discussed, and to the survivors who are still alive today. And I would also appeal to you to urge your fellow lawmakers to undertake to have the courage. This is not indicative of weakness, but of strength to address these human rights abuses, blatant abuses that were inflicted on women and sanctioned by those who knew better. Well-educated people with professional designations were deeply involved in these activities. And one other thing I want to show you, could you please hold up the birth certificate? I have anyone who wants to examine this birth certificate, this is an original birth certificate of my adoptive mother, which offers you tangible proof that they lied, that they perjured themselves on the sworn affidavit that was sent to Judge George Tweedy of the PEI Supreme Court, where they swore under oath that at the time the affidavit was executed, they swore under oath that my adoptive mother was 49 years old, when in fact she was 51 years old. And they also swore under oath that I had been in the adoptive home for a period of 21 months, when I in fact had been there for a period of 6 months. These details matter. They matter because lawyers were involved, the board of directors of the Protestant Family Service Bureau were involved, some of whom were lawyers. Judge George Tweedy didn't take the time to examine any of the unsubstantiated claims that were sworn to in the affidavit signed by my adoptive parents and by the Protestant Family Service Bureau. So I'm pleased to answer any questions that you may have. And in closing, I want to assure you, I was not the only innocent child to be handed over to alcoholics. This was not mere happenstance, what happened to me. My adoptive mother had 4 adult children, and these scoundrels at the Protestant Family Service Bureau didn't so much as make an attempt to contact her 4 adult children from her previous marriage to inquire about her suitability or her capabilities. There were no character references sought. There was no background check done. There were no home visits that took place. So Walter Baker was instrumental in inflicting 3 generations of grief on my family. He did this to my mother, he did this to me, and now the 3rd generation is carrying the burden of this unspeakable act. The person sitting next to me is the 3rd generation who has to live with the consequences of what happened to my family. I'm not here to lecture anyone. I'm here to enlighten and to set the record straight that this institutional system of abuse and perpetrating shame and humiliation has got to stop. It's being inflicted now on adult adoptees who are being denied details that they need about the circumstances of their birth, about their predisposition to genetically inherited diseases. And I haven't even touched upon this with you. I inherited a devastating form of muscular dystrophy that is so rare that there's only 1 case per million. And I've consulted with genetic experts in Ottawa, in Bethesda, Maryland, and also my doctors in Halifax, who went through, and it was greatly complicated, the matter that I was adopted, and they kept insisting that this mysterious illness that I had was genetically inherited from both my parents, my biological parents. And now my son has inherited a copy of this recessive gene. Mercifully, my son is not going to develop this devastating illness that I have, because it's a recessive gene and 2 copies have to be inherited for the disease to manifest itself. And this is another dimension of my adoption that I haven't had time to touch upon. But the bureaucratic obstruction and the entrenched secrecy that inhibits the rights of adult adoptees to get to the bottom of these genetically inherited illnesses is a human rights abuse on its own, notwithstanding all of the other corruption that these adoption agencies were immersed in. So I'm very happy once we conclude and Charlotte has a chance to address you, I'm more than willing to answer any questions that you might have about my adoption, about my experience with my adoptive parents, what I had to survive because of the negligence and the bigotry of the people who were taking newborn infants from their mother and getting away with it for at least a couple of decades here on the island.
Thank you very much. I mean, that was so brave of you to speak today. So, so what we'll do is we'll pass it over to Charlotte at this time to speak, and that's okay. Or is the committee okay with moving right along? Okay. Thank you very much.
Okay. Hello, everyone. Thank you for the opportunity to speak today on the topic of adoption disclosure legislation. My name is Charlotte MacAulay, and I am a mother of loss. I'm here today to speak for myself, but while you're listening, I would ask that you keep a few things in mind. First, there are thousands of other mothers on PEI who have adoption loss stories of their own. And second, beyond PEI, there are hundreds of thousands of mothers whose stories hold pieces of mine. And third, disclosure legislation is not about children. It's about adults, plain and simple. Adults who are adoptees, mothers, fathers, and siblings who have lost connection with their origins and their families. I'll try to explain what needs to be included in adoption disclosure legislation in order to accommodate all adult adoptees and natural families who have adoption records held by the province of PEI. Historically, the language of adoption has been about choice. You may have often heard the phrase, "she chose to give up her baby." Well, I'm here to tell you that there was no choice involved. There was coercion and pressure to do the right thing. It's insanity to even think that a parent would consider having their child taken from them as a viable option. We mothers had no choice, and adoptees certainly had no choice. But now, when we are all adults, choice is still held at arm's length. But you as lawmakers have a choice to make things right. So what is adoption disclosure? Adoption disclosure necessitates the release of information held in adoption records. It's not about information being released for public consumption, but rather the sharing of information with adult adoptees and natural families. Information about who the other party is or has become. PEI adoption disclosure legislation has evolved over the years, and it's essential for it to change again in accordance with the times. Before an amendment in 1969, there was no legislation regarding adoption disclosure. And there's no historical evidence as to what disclosure, if any, was sought or given before then, but that amendment added a provision preventing disclosure. And more amendments were made through the years, including in 1992, 1995, and 2000. Each time, adjustments were made regarding adoption disclosure, but each time the Child Welfare Department kept control. Adoption disclosure legislation is not about child welfare. It needs to be treated as a public service for a specific group of adults. If they choose not to avail themselves of the service, fine, but it needs to be accessible for everyone. For decades, Mary already mentioned this in detail, but for decades there was a deep prejudice against vulnerable women in PEI. Through the hands of both church agencies and government, that translated into an untold number of adoptions. And this happened across the country and around the world as well. We can't change past attitudes, but what we can do is lift the barriers so families can find one another today. The latest amendment to adoption disclosure was Bill 29, and it was enacted in 2020. Some of you here were probably a part of the debate for that. And it's a start, that amendment, but more can be done. With Bill 29, adoptees born in PEI have access to some birth information, and some natural families have access to the adopted name of their son or daughter, but not everyone does. When an adoption crosses borders, either provincially or internationally, most legislation defers to the province or country where the adoption took place. The PEI legislation needs to open the records for all involved in a PEI adoption. If the province holds documents in a record, then the lawmakers should have the power to decide what happens to those documents. According to the Department of Social Development and Housing, there are more than 4,000 adoption records held by the province of PEI. So to put that in a bit of perspective, at the very least, 8,000 people should be eligible to receive information concealed in those files. I'm one of those 8,000, and so is my son. I was 17 when my son was born and taken from me. About a decade ago, I began the journey of looking for information. It hasn't been easy. I have very little memory of my experience, and part of what is so important to me is to have access to information so I can take back those memories and to see the physical evidence of exactly what took place during my time at St. Gerard's, a home for unwed mothers, which was run by Catholic Family Services in Charlottetown. My son was adopted in Ontario, and I did receive non-identifying information from the Ontario agency through which the adoption occurred, as per that province's legislation. But it was only with the help of others in the adoption search community that I was able to ascertain what agency to even contact to get that information. I also received a small amount of non-identifying information from PEI a couple of years ago. But when it comes to identifying information, I don't exist in either jurisdiction's legislation. In a recent meeting with PEI Post-Adoption Services, we discussed how this could be rectified. They contend the 2020 legislation wasn't drafted to intentionally leave anyone out, but yet here we are. They also say they are working towards finding a solution for those who are left out, but they stop short of saying that they could do that by changing the legislation again. I'm not an expert on legislation, but wouldn't it make more sense to work towards making the laws clear and concise rather than trying to find ways around them? I think the only way it can be rectified is if we change the legislation to include everyone. These records are a piece of our history that shouldn't be kept hidden from us. Make the legislation relevant to what we, as adults, are looking for. It is an ask for information. We don't need social workers to control what we find out and don't find out. Adult adoptees are no longer children, and many of us who were young mothers are no longer children. It's time for the government to step back and look at the service as purely that, a service they provide for a segment of the population. That being said, there is room for some type of counseling when it comes to adoption trauma. Yes, adoption trauma is a real thing. The one thing adoptions all have in common is that they begin with loss. And for many adoptees and mothers, that loss results in trauma that can manifest itself in many ways. For me, it is my memory loss and the unending grief that comes with not knowing who my son is. Some people would greatly benefit from counseling or therapy, and it's important service that the province should seriously look into providing. It needs to be offered by professionals that are trained in adoption trauma. I know I kind of went off topic there, but I thought it was important to mention that, so I would be happy to further discuss this with any of you who want to know more about that topic. But back to the legislation. The following are a few things that adoption disclosure legislation needs to include. 1, change the legislation to reflect open records for all involved in an adoption where the adoptee was born on PEI and/or for all the adoption records held by the province of PEI. Digitize the adoption records that are still in existence, because I'm sure that there are some that have gone by the wayside because the province says they have been keeping adoption records for 100 years. The current legislation already states reliable records of placements and adoptions must be maintained. However, I have been unable to get a clear answer as to exactly how many adoption records the province holds and even where they are all located. And this needs to be rectified, and soon. None of us are getting any younger. If records are scattered between vital statistics and social development and housing, then perhaps there has to be a concerted effort to combine them. Clear and concise policy should be written in the legislation on how information is to be released to those who are eligible, and it needs to be kept updated. Make the process as simple as possible for those applying. Once people decide to begin their search for answers, the last thing they need is a minefield of legalese to contend with. Give adoptees a copy of their birth registration as opposed to the prescribed information they receive now. Did you know that adoptees are the only citizens not entitled to have an actual copy of their original birth registration? And further to that point, allow adult adoptees and natural families access to all documents in the adoption file. If there needs to be redactions to accommodate not naming other parties involved, that's fine, but the original documents paint a clear picture when someone is trying to piece together their history. Serious consideration should be made to moving post-adoption services to Vital Statistics or the Office of the Privacy Commissioner. That way, it would be strictly an information service. If my son's adoption file holds documents relating to any of my experiences during that time, there should be no barrier to me having access. Vetoes and contact preference undertakings in the current legislation need to be taken out. A veto provision allows someone to block the information the other party is seeking. This should not be allowed. Privacy and information are two different things. The information should be accessible for everyone. There's also a provision in the legislation where a person must sign an undertaking promising not to contact the other party if the information is released when a no-contact preference has been stipulated. If they break that undertaking, there can be a fine or jail time implemented. Undertakings are for criminal activities, and it is insulting to have even a hint of criminality associated with our adoption experiences. How can you justify criminalizing people who are looking for family? To me, this is just another way the department is continuing to hold control over the people involved. A contact preference form without undertakings attached would suffice. I'm not sure if you all have a copy of The Shame is Ours. Mary, did you include it? Okay. 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 So you all have a copy of that. It's a 2018 Senate report that took a long, hard look at past adoption practices in Canada. And it's very relevant to what we are speaking to today. One recommendation of that report calls on the Government of Canada to collaborate with provinces and territories on this status of provincial legislation governing adoption disclosure. While the federal government, no surprise here, has yet to respond to any of the recommendations, I put it to you as provincial legislators to initiate that conversation. As legislators, your role in this is critically important. It is time to bring the disclosure laws up to date and in line with what adult adoptees and natural families are looking for. Across the country, jurisdictions claim to have open records, while none are completely open. So don't look to follow past practices. Be bold. Take the lead in creating legislation that truly opens the records for all. Legislation that the federal government can look to for a model. I realize that you have had a lot of information thrown at you in a short time, and I hope I can answer any questions you may have. Thank you.
Well, thanks very much, Mary and Charlotte, for your great time here. I think it's very important. So we'll open up the floor for questions from the committee members at this time. Anybody has anything? Yeah. Carla?
Thank you, Chair, and thank you so much for sharing your stories with us today. It's beyond bravery what it takes to share those stories, especially in a room such as this one. So the very room that would have contributed to your trauma. And so that goes, I see that, so thank you. I have so many questions, yet I don't even know how to put them into words, but I guess you've shed such an interesting light on this. We don't talk about how these adoptions happened. And so when we don't have that information, which you have so graciously shared both through your words and through the documentation you gave us, this sheds a whole new light on it and gives context to this legislation that, I'll speak for myself, I didn't have before. People don't talk about this. I know it's happened in my family, and so hearing your words was, I had my own things attached to them. And so, sorry. I feel that when we don't have this information as legislators, and it's here, it's not, I could have looked for it, but I didn't even know it existed, but I assure you that I'm looking at this in a whole new way. And so I guess my question, so whenever we say open records for all, why do you feel that that was not included in this legislation? Are there any thoughts on that?
Yes. So this legislation, so adoptions cross borders, I mentioned before. So my case and my son's case is an example. My son was born in PEI, so he has a PEI birth certificate, but his adoption was finalized in Ontario. So in the PEI legislation that's there right now, they say, well, his adoption wasn't finalized here, so we can't give you any information. And in Ontario's legislation, they say, well, he wasn't born here, so we can't give you any information. So they're not open for all. And I just want to give you a little insight to what happened back in January when they did open the records. There were several adoptees from Ontario. Adoptees who were born in PEI adopted in other places, but we'll go with Ontario. There's at least 2 there. So when they applied, they got a letter, the same letter I got, saying, oh, we can't give you that information because your adoption wasn't finalized here. But the only place that those adoptees can get their birth certificate is from PEI. And it took 3 months of us hounding the department for them to realize that it's already there in the legislation. It's obvious that they can only get their birth certificate here. So now those adoptees can get their information. But us as natural families are still left out because the adoption didn't happen here. They say that the official adoption order, which would have been an Ontario document in the first place, they say because that's not a PEI document, they can't give it to me. And that's the only information that I'm looking for, apart from my personal files, would be the adoption order that has the name that my son was given. Not the adoptive parents' names. They can be redacted. I'm not looking for them. I'm looking for my son. But because that was an Ontario document, PEI says, well, even if we have it, we're not allowed to give it to you. But I contend that if it's in a PEI file, it's a PEI document. If it's an official copy that Ontario sent to them, then it's a PEI document. So whatever is in those files needs, under the legislation, needs to be free to give out to the people who need it.
Carla?
Thank you, Chair. And thank you for that. So putting this all together now in terms of in the talks with federal government and how important it is that all provinces be on the same page so that there's not all this bureaucracy and red tape, especially when we're talking about something that is so delicate and so forcing mothers to give up their children and criminalizing them for being unwed, for being widowed. The shame is in that. Yeah. There. It's in nothing else but that. And let's add this to the list of shames we have in Canada right now. And I'm going to leave my questions for right now and see if anyone else has any questions. But we'll be looking into this a lot with this new kind of context, looking at this in a whole new way, and thinking about this in a whole new way. So I may have more questions after, but I'll stop for now. Thank you, Chair.
Thank you. Okay. Zach?
Just to reiterate what Carla said, thank you both for sharing your stories. Just something that you had touched on, Charlotte, with the adoption, trauma, the counseling or therapy. Is that something that, do you know, is done in other provinces or other jurisdictions, or?
I'm not sure. I don't know if there's any other provinces that actually participated in it. And to be fair, the PEI website says that there is counseling available if needed. I've never availed myself of the provincial counseling because they've done enough for me already in the opposite direction. But I know that there's quite a large community of adoptees and natural families because of social media, and we're from all over the world, and we connect. And I know that across Canada, there are several therapists who do adoption trauma properly. They know all about it. And I can absolutely connect you with Origins Canada, who is a nonprofit that helps people to deal with the side of adoption that we're talking about today.
If I could just
Sure.
comment very briefly to what Charlotte has said. I think a way of looking at it is non-oppressive counseling. No one needs counseling from agents who support or supported the status quo, who would attempt to normalize these practices, trying to defend the indefensible, if you will. So I think it's important to make a distinction when we talk about counseling. These agencies, under these religious agencies, let's be frank, this was the church interfering and meddling in the private lives of citizens that unleashed all this trauma in the first place. It was at the invitation of the legislative branch of government that delegated to religious agencies with these judgmental attitudes. And then it was open season on these women. So their primary targets were unmarried women, but also included within their ambit were widowed women and separated women. So if a woman showed up at hospital, for example, and fit into any of these three stigmatized categories, then she had no choice but to deal with a social worker meddling in her life. And we need to dispel this myth and confront it head on, that social workers were mindful of human rights. They were active agents of oppression. And that can be demonstrably proven. We don't have time to delve into all of that here, but that's another subject for a thesis in itself.
Thanks, Barry. Zach?
Thank you, Chair. Just one, maybe last question, again for Charlotte. Just in your presentation that you kind of included for us, you mentioned the disclosure legislation should include, and you list a number of different things that you believe. Is that in the order that you think are the most important, or is there, maybe a couple of these, or are these equal?
In there because they're not there now.
And there's no. Sorry, Chair.
Sorry, Zach.
Yeah, and is there like one that you feel is maybe more, or two that you feel is more, or are they all equal important?
They're all equal.
Thanks, Zach. Great. Rob?
Thanks, Mary, Charlotte, and Reese for your presentation. Certainly, it sort of really pulls at your heartstrings, and hard to imagine that these types of situations occurred in our society, and relatively not all that long ago, so I appreciate your candor in this. You'd mentioned that there's about 4,000 adoption records with Prince Edward Island that currently is entrusted to maintain over the last approximately 100 years, I believe. So since the legislation did change in July of 2021, have you since met with the minister responsible at the moment to sort of get a sense on what the issues are since the legislation changed and how it hasn't been corrected in your situation, and what sort of response back did you get?
I have attempted to meet with the minister, and I was sent to Post-Adoption Services to have a meeting with them. And I did have a meeting with them. And I came out of that meeting, I told you what happened at that meeting, and I came out of there and I decided that I'm not going to be pushed back to the department once again. That happened back in 2017 when we wanted the records open in the first place. And immediately it was shoved to the department and they dealt with everything. And what came out of it was disclosure legislation that's just not good enough. So when I came out of that meeting with Post-Adoption Services at the end of May, I said to myself, that's not going to happen again. I did attempt to, I sent an email to several, I don't know if you guys were any of the ones that were on my radar for that email back in June, but I got a couple of responses. What I wanted to do was make my own bill because nobody's making the bill that we need. I got a couple of responses, but Sydney, who's not here today, said that the most impact it would have for a bill would have to come from the minister. And since the minister keeps shoving me back to the department, and it was Mary's suggestion that we try this, and I'm very glad that we did, because it's you guys that we need to talk to. It's no good us talking to the department because they know how we feel, but they have their policies. And they are going to keep insisting that we don't need to open everything up. We need to keep control of what you guys see. And that's not going to change unless you guys kind of talk about it.
Rob?
I feel that the minister then is, but as the minister is the representative of the people, and it's the minister's responsibility to manage the bureaucracy so they can provide what people require in providing services. So have you been given any indication what is that they don't support in what you're trying to accomplish? And I guess my other question to add to that, so when we said that the legislation changed and people could implement a veto, have you been given any indication how many people actually implemented a veto on this? Because that would sort of give you a sense of how many people aren't supportive.
Somebody asked for the numbers back in December or something like that. There was about 20, a couple of dozen vetoes, I guess, that were implemented. The number is not important to me because just one is no good. Because if there's one veto, then there's one group of people that are not getting what they need to have.
Rob?
Does 21 sound high? To me, it sounds high, but
I really, the numbers of vetoes don't matter to me. It shouldn't be there at all. And if people want to put in a veto, like you're saying, that are you trying to say, like those 21 people, they're important too? Because obviously everybody has, their own journey to take. But they can still take that journey without a veto. They can probably maybe even go through their lives with not even being contacted by the other side. Or they could be contacted and we're all adults and they can say, I just can't deal with this right now. And we're adults, we're not criminals, we're adults, and we'll say, okay, well, that's the way it is.
Thanks. That sounds reasonable, because I don't know if it's a high number or not, but it sounded high, I guess that's where I'm kind of thinking.
Well,
So
if there's 4,000 records and 20 vetoes, it doesn't seem very high to me, but I'm not a math person.
So there's 4,000, so that's back 100 years,
Yeah.
correct? Yeah, so that's where I was kind of thinking, if you're dividing that up by that many years, it sounds high.
So I said, like, potentially, if there's 4,000 records, there's at least 8,000 people. It takes 2 people to make a child. So there's more than at least 8,000 people affected by this. And there's also my sons and daughters, siblings of my son, the people that, records from 100 years ago, you know, that adoption happened 90 years ago. The next generation is looking for their family.
And I think the other point would be genetic issues from, you know, for whatever reasons, can skip generations and stuff like that. So there would be some importance to kind of get those records back. Yeah, so, example of that.
Poster child.
Yeah, exactly. So, anyway, thanks very much, Chair.
Thank you. Trish?
Thank you, Chair, and I also want to thank you for coming today and for sharing your stories and highlighting some of these the issues with the, you know, your concerns with the legislation from a perspective that we may not have considered before. A question I have that is, it's not really a question I have for you, but something that's sort of flagging to me after listening, Charlotte in particular, to your experience, would be, you know, I have questions about what sort of a jurisdictional scan was done and what efforts were done, you know, to, or have been completed to engage with the other provinces, because the intention of the amendments, you know, whether we agree with all of them or not, it sounds like some of those intentions are being blocked by the conflicts between the legislation in different provinces. So as a baseline, you know, if the intention was to open up records within certain parameters, it seems that the amendments have failed to do that based on the interaction with other provinces as a first sort of initial problem here. So I guess I don't really have a question for you on that, but I just wanted to say that to me that seems like a very important question for government who has, you know, who put forward those amendments. You know, what because that's a basic, right? When you're putting forward legislation, you do a jurisdictional scan, and if you have a piece of legislation that's going to interact with other provinces, you need to understand how that's going to work and if it's going to, your legislation is going to achieve what you're trying to achieve, right? Yeah. So, that was really more of a comment, and there's no way that you can answer that, but it's a question I have now.
Myself, and have not really gotten a straight answer, because I've known since I started my search that there was a conflict with Ontario. And from the time that they said they were going to open records, every chance I got, I kept saying, well, what about Ontario? Because I knew it was different than the other provinces. And I kept being told, well, you know, we're going to cooperate. Everything's going to be fine. When I got my rejection letter, I did apply because I wanted a paper trail to prove. And when I got my rejection letter, the address of the person that they sent me to in Ontario to look into my records, she didn't even know her name was on that paper. When I contacted her, she said, I'm sorry, you have the wrong department. And I said, well, do you know that your contact information is on this letter from the PEI government directing me to you for information on my son's adoption? And she said, no, absolutely, I don't. I'll check back with them. So there was a lot of inadequacies done. That's why one of my recommendations is clear and concise policy. Because honestly, they're just winging it as far as I can see.
Trish, that's it. Okay. Carla?
Thank you, Chair. And there's a lot of winging it going on. And this is another example, and it's something that I've been getting increasingly frustrated with. So two things. This might be more of a question to Samantha. The jurisdictional scan that Trish mentioned, as well as the questions that Charlotte and Mary brought forth on records and how many the province holds and where they are, and the need to have them centralized. Is that information that we can request? It may not be now, if maybe under new business.
We can request whatever, yeah?
Yeah.
Any committee member can request.
I would like to request that information for the committee.
Okay, we'll put that on there, and we'll see if we can do some research on that, potentially.
Thank you, Chair. And the other thing I was going to say, that the conflicts between the provinces, and they're not fair, and they they compound trauma. With the thought, if I just lived in this province, I might be able to get more information, and that's horrible. And, we're dealing with the trauma of babies being ripped apart from their moms. And it brings to mind, and I'm just curious if you have no comment on this, I totally get it, but it brings to mind the fact that currently in PEI, our Child Protection Services are undergoing a review. And I'm wondering, in this case, it's a little bit different because we're dealing with adult adoptees. But I'm wondering, as we consider things like birth alerts, right, we no longer practice that as a province. But if a mom or a family for some reason were red flagged, social workers would go into the hospital and things would go from there. But I'm wondering if there's anything from, Mary, this may be particularly to your experience, but also you, Charlotte, as the mom of the baby who was taken. I'm wondering if there's anything that you would like to comment on in terms of what you might look for, not exactly adoption legislation, but child protection legislation, if there's anything that you can think of that you may be looking for in our child protection legislation as it pertains to adoption. Does that make sense?
In the current legislation or the past legislation?
So right now we're looking at updating the current
Right.
legislation. So I'm just wondering if in the new legislation, if there's anything that you would like to see based on your experiences, if that makes sense.
Well, my past experience, and I've spoken to the coercion and the demonization and the treatment of these groups of women up until about the time when the Charter of Rights was passed in this country. So I just want to point to the tangible example of my own mother, Verna Isabella MacLeod. Every document refers to her as a single woman or an unmarried woman. Now, that was not a neutral, benign term. That was an accusation which stripped these women of the right to due process, of the right to appear before a judge and plead her case. Never was it ever demonstrated that my own mother or any mother who was surrendering a child for adoption, it was never suggested that she was an unfit mother. They didn't have a case against her. Their case was sufficient in that she was labeled unmarried, and therefore she was stripped of any agency, of ability to appear before her accusers. Her accusers were the adoption agencies. In my case, the Protestant Family Service Bureau and the Catholic equivalent here on the island. It needs to be understood. They were not, they posed as helpers. But in reality, they were their accusers. And the accusation was that they were unmarried. And as I mentioned previously, an elaborate edifice of lies and myths were built to reinforce this entire adoption system. It's predicated on a lie that these women were granted lifelong secrecy. So these agencies and their aiders and abettors in government and in the judiciary were complicit in stripping these women of their legal and autonomous due process rights. And therefore, any supposed promises that were made by anonymous individuals were null and void, is what we're saying. These promises that the status quo keeps invoking, as happened during the debate in the PEI legislature a couple of years ago, have no merit. These were human rights abuses that occurred, that were inflicted on an industrial scale at times on these women. And therefore the law is indefensible. A law that is derived from committing human rights abuses is a corrupt law. That is what we are saying today. And this is not some revolutionary concept that we're putting forward. This has been acknowledged in Australia, that these practices were utterly corrupt and derelict, and that these women were abused and were stripped of their rights as citizens. This is no longer up for debate. You know, if you look at the statement that was given a decade ago by the Australian Prime Minister Julia Gillard at the time, is a landmark speech, and the President of Ireland has acknowledged this, what I'm telling you here today. The government of Northern Ireland, so this is Great Britain that we're talking about, released a comprehensive report. These allegations that I'm making here have been acknowledged and endorsed by governments. This is not a theory that Mary MacDonald came up with. And it's therefore futile to even begin to engage in a counter discussion that these were not blatant human rights abuses. That has to be the benchmark from which we proceed. That these laws that transfer, it began with the stigmatization and demonization of the mothers, and through intergenerational adjustments that were made to the Adoption Act over the years, was a transfer of that discrimination and of that stigma to the offspring of these women. So it's an intergenerational transfer of discrimination. The mothers bore the burden in the first instance, and then their offspring became demonized, and it became institutionalized and defended as practice by those with a vested interest, whose careers are, have a stake in upholding the status quo. So this is why you hear well-meaning folks like the two witnesses from the Department of Child Services here on the island who attested to the myth that lifelong anonymity was promised to these women. There's not a shred of proof, but yet they will swear to their last breath. Anyone who has a stake, an institutional stake in the status quo, whose career is embedded in these policies, and who who reproduces this publicly in defending these policies is not going to advocate for change, is going to be unwilling to acknowledge that these casting aspersions on the motives and of the validity of adult adoptees who are simply seeking their origins and facts, about their genetic heritage in some cases. They're being, depicted as being up to no good and having malicious motives, and that this is somehow causing trauma to people.
Trauma was already there.
Right. The trauma was already there, as Charlotte has said, and this is a natural human instinct. But yet, it is still embedded in the Adoption Act, and it is incompatible with the Charter of Rights of this country. To cast a stigma or to arouse this kind of suspicion of malice or bad intentions. This current Adoption Act that you have here on PEI does that. It targets adult adoptees as being prone to harass other people. That their mere presence, their mere existence is bothersome to some people. The fact that they were born is disturbing to some people. And they're being indicted in the same way that their mothers were the generation before. As I mentioned, every time, every document that was produced by these agencies and that ended up on some judge's desk referred to these women as unmarried women, as single women, and these were not neutral terms. These were accusations that gave them the power to deny these women the right to speak, the right to be heard, the right to due process was denied to these women. They had no objective, neutral person to state their case.
I can kind of connect that with today, Mary, just to briefly respond to what you were saying. I'm really glad birth alerts are gone. And I just happened to look on the website the other day, and there's actually an adoption pamphlet that's still on there. It's from 2011, but it still shows adoption as a choice for a mother. There definitely should be an adoption pamphlet for people who want to adopt children who are orphans, but that's coercion right there, and it's 2011, and it's still on the website. So just to speak to child welfare legislation, family preservation first, and maybe get rid of the coercion.
I just want to thank you for coming in, and I have a couple of questions. So when you were talking, you mentioned about privacy versus information.
Mm-hmm.
Can you talk a little bit more about that? Because that seems like when the debate was going on, it seemed that it's always a fine line between.
So privacy is the, I guess, the gold standard for the vetoes. People say, well, you have no right to give out my private information. Well, I'm sorry, but It's not like my name is not my private information to my son. It's his mother's name, right? Vetoes should not be there. The only reason that that veto is there, Mary touched already on the myth of secrecy, but also in 2007, Ontario was going to open with no vetoes. It was going to be the first province in Canada to open with no vetoes. Somebody took them to court. So they put a veto. They didn't challenge the court case. They didn't appeal it like they appeal everything else. They just said, okay, we'll put the vetoes on, and that was that. So it didn't even go past Superior Court. But yet, how many years later, PEI is using that as an excuse to put a veto in their legislation. So there's states that are opening now, there's no vetoes. It's none of this is about privacy. You know, my son has every right to know what my name is, and I have every right to know what his new name is. If it's not, you know, I'm not invading his privacy by knowing his name. I might look at it for 10 years before I even call him. I might be 10 years before I'm able to find him. Like, that's got nothing to do with this legislation. So that's why vetoes shouldn't be there.
I'm concerned as well about, I mean, we look at it internationally, then you break it down to nationally, and you break it down to provincially, and the trauma that you suffered, Mary, and the trauma that your family suffered, and the human rights issues that we looked at. I don't know how big an issue that was on PEI, and I think it's more important that we kind of explore that, and I really appreciate you bringing it forward, because it doesn't sit well with me. It doesn't sit well, I don't think, with a lot of people in Prince Edward Island. So I'm going to take that away today, and your words, and Verna Elizabeth McLeod was your mom, and I just wanted to say her name. So what we'll do is the committee will talk about this, and I think that this is an important day, and I just want to give you, like, maybe if you need another minute to think about anything that we might have forgotten, or if anything you want to say to the minister or anything at all, feel free to do that now.
I just want to confirm that everyone present has a copy of the publication that I circulated. I'm not sure if everyone yes. Did everyone?
Yeah.
Did you get? Okay, could you give the gentleman in the back a copy, please? And I'd like to also give you a copy, Ms. Bernard, for the Leader of the Opposition as well.
So we didn't touch on DNA today, but I just kind of wanted to mention that DNA makes everything that we're doing here today practically moot. Like, you know, we're looking for all this information that's concealed and that we can't have. And there are just so many people finding each other through DNA that it's doubly frustrating to have this little barrier in our way.
Mary?
I have to excuse myself because we have to head back home.
Or
I want to thank you kindly for listening to our stories today. And in closing, I would request that you have the courage to be leaders. You have a chance now to show real leadership for Prince Edward Island. Typically, historically, Prince Edward Island has been a province that follows the example of others. But you have an opportunity in this regard to be brave and to really put Prince Edward Island on the map as a human rights leader. And we would really appreciate your consideration of these matters. We don't come forward with vengeance, but only truth and justice are our goals.
Great.
Charlotte, I have to go.
I know. Thank
And please do not hesitate. Miss Lily knows how to get in touch with me if you have any questions at all that come up with respect to my comments here today. I'd be more than happy to follow up with any of you. Thank you very much.
Thank you very much. Great. Thank you. So we're concluding right now, so if that's okay, or, okay. So what we'll do is we'll take a brief recess, and we'll allow our guests to leave, and then we'll continue on with just wrapping up the meeting. Okay, we're back to wrap up. Just briefly, recapping number 3 with our presenters. There was a request made by a committee member, Carla. So I might just get you to repeat for the clerk, or the clerk to repeat back to what we're doing a scan on.
Okay. So as was mentioned during the meeting, Trish had mentioned a jurisdictional scan on what other provinces were doing, and if we had taken that into account when we were writing that legislation.
Yeah.
Trish? Yeah.
Yeah, exactly, and I think in particular, since the act has been amended, how do those changes to the act interact with the other provinces? I think we need to get a better sense of that, because there were, the intentions behind those amendments, as I recall, was, to open up records, with still those veto provisions that, maybe questionable in different ways, but that aside for now, the actual intentions of those amendments were to open up the records, barring those vetoes, those few examples, right? So it sounds like that's not actually happening if someone, an adoption, a birth happened on PEI, but the adoption happened elsewhere, or, if there's some other interaction with another province where we're not achieving what those amendments were actually set out to do. So an understanding of how the Act currently interacts with other provinces, I think would be really valuable, but I open that up to the.
Okay, perfect. Okay, Ola, would you like to comment on that?
I just have to comment, I was slightly involved in asking about jurisdictional scan made across the province, and not in Ontario, but one of the other provinces. It was taken to court, to the Supreme Court in the province, I think it was Alberta or Saskatchewan, which is why the province chose to keep the veto in here.
Yeah.
Anyway,
Thanks
just
for that
a
comment.
bit of history.
Yeah, thanks. Trish?
No, thank you for that, Ola. And that's actually not specifically the question that I'm asking, though, about the vetoes. It's, as a first step, the intentions of the amendments that were passed in the legislature, do they actually work when having to interact with other provinces, and where are those barriers? We've got one example here today, but I suspect there might be many others, and that's something that really should have been taken into consideration beforehand. So if there are further amendments needed to even achieve what was originally intended by those amendments, then that's something that this committee could look at, I
Just a
think.
question to the committee. Is this something that we want to do the work on, or do we send a letter and ask for the information from the department on these questions in particular?
I think that's a fair question. That was sort of my first question, was what work has already been done on this, and was this looked at? But, I mean, it would be good to know, I think, at this point, where the gaps are.
Yeah.
So,
Carla?
Even if we were to reach out to the department and ask them those questions, then just kind of a process question is is the committee able to request that one of the research people complete the jurisdictional scan if that hasn't been done already? Is that a reasonable request?
Yes.
Okay.
Yes, so we could do it as a two-part, if the committee wishes, where we could send a request to the department to see what was done, and then as a secondary part, we could pass it on to the research team as a project to do a scan.
Does that
As well.
sound good for the committee? Okay, perfect. So we'll do a two-part on that, sure. Is there, Carla? Yeah.
The second part to that, Chair, thank you,
Sure.
was when Charlotte had brought up that they've been asking the province about how many records the province holds and where they are, and the need for those to be centralized and digitized. But I would put out the question to the department, how many records exist and where are they? If that.
Yeah, because she did mention vital statistics or social development and housing. So that's a good question. Just looking at the things that she had mentioned. Okay, perfect. And is there anything else around that topic that the committee would like to do after those presentations? Okay, no, okay, perfect. Thank you, appreciate it, everyone. So at this time, we'll move on to number 4, new business. Does anybody have any, Rob?
Just, I know it's a bit of an issue near and dear to your heart, but have we done anything yet on the issue around presumed consent when it comes to organ tissue donor issues? I think that was something that was going to be one of our topics.
Yeah.
Maybe an update on that might be helpful.
Yeah, that is on the work plan, so I can definitely get an update on that. I think that we had decided on Stephen Bede as a potential presenter, potentially in September, if that's still something the committee's interested in.
Yeah. Rob?
Yeah, I would say yes. I mean, that or the Medical Society of PEI, something just to sort of see where that one's at.
Perfect, yeah, good. Thanks, Rob. Carla?
Thank you, Chair. Just a quick update, I'd already
Okay.
emailed Samantha about this, but just for the committee to know, I was able to touch base with Doris Payer, who one of our work priorities was ACEs, so adverse childhood experiences. And so she is really looking forward to zooming in to a meeting in September. So just an update there.
Okay, perfect. Okay, and we're at July 21st. It's hard to believe already. Could I just get an update from the clerk about when our next meeting would be? Do we have anything lined up between now and the foreseeable future? And, yeah.
So the next things I have the ACEs, the Adverse Childhood Experiences, in September. A letter is still yet to go out to Kelly Peck from Child Protection Services. And then I'm in the midst of scheduling with the Native Council of PEI, and that would potentially be for a meeting in September as well.
Okay, great. Does that sound good for the committee? Yeah, so, okay, so, great. And I guess with that, we will, if everybody's okay, we'll call for maybe, Zach?
Say if you're calling for adjournment, that was going to be me.
Okay, Zach.
Getting ahead of myself, right down
I
there.
think it's time we give it to the new guy. Zach Bell
Adjourned.
called this motion to a conclusion. Thanks, committee.